All right, well, welcome everyone. Thank you so much for coming to this Meridian Library District program. If you're new to Zoom, then here's your first foray. It will be pretty self-explanatory, but I'll go over a couple of things. If you have a question for our presenter, you are welcome to use the right-hand side for chatting. Mark will pause at specific points and I will relay those questions to him. We are going to be covering the basics of tonight, but we are happy to report that Mark will be with us for two other sessions of this series, the Files for Life series. So if he doesn't answer all your questions here, we will have an opportunity to speak with him again. But without further ado, I'll give you a little information about Mark. He is the founder and president of Idaho Estate Planning. He's an expert on estate and legal planning, as well as asset protection and tax planning. He co-authored several manuals in the areas of probate administration, estate and estate tax planning, and asset protection. And he's also the author of Get Real Planning for Life, Death, and Disability. So he is an excellent resource and a wonderful community member that we were very happy to be co-hosting this program with.
All right, so let me get started. Tonight, and again, thank you to the Meridian Library District for putting on this series, Files for Life. Some things that they asked me to talk about, I think, are just awesome for people to have an understanding and a background with. And so I'm going to cover some general things tonight. In 4 weeks, or the fourth Tuesday of July, we're going to do this again. We're going to be talking about powers of attorney, and I'll talk about that just a little bit tonight, but in that one, we're going to talk quite a bit more about that. And then in the third one in August, we're going to be talking about wills and trusts. Is there a difference? And you'll see tonight, we're going to talk about it briefly. And then when we do that again in August, we'll get in, we'll drill into it a little bit so that we have some more information available to you. So, okay, let's get going. So one of the things that is most interesting for people is when I say that I do estate planning, one of the first things that they tell me, like all the time is, well, I don't need to do estate planning because, well, Mark, I don't have an estate. And of course, I think this is Downton Abbey. And so if you're thinking in terms of Downton Abbey, most people don't have a Downton Abbey estate, with the big main house, and we've got the stables over here, and then we've got some equipment over here, and the big manicured lawn and all that. Most people don't. But in the legal field, estate refers to assets that you own at your death. Or if you were incapacitated and we did a conservatorship, those assets together under the Idaho statutes, that's an estate. And so everybody has an estate. Even if you said, well, Mark, all I have is debts. I just owe money. So at my death, they don't have an estate, and the answer is still, and this is weird, I get it, but even if all you had were debts, that's still considered a legal estate, and that requires some planning. So, what are some of the other things in an estate? Well, your house is part of the estate, your automobile. I can't quite tell what that car is, but it's an older one. It's got the old 3 on the tree standard shift. And that's awesome. That's part of your estate. If you have records, and here, of course, they put the 45s and the 33s, but I mean legal records, financial records, finances, financial accounts, investment accounts, bank accounts, and nowadays, assets that you hold online. So this will sound weird, and I probably really need to do a presentation on this, but like your Facebook account, that's part of your estate. And you're going, well, yeah, but it's not worth much. No, but it can sure be a problem to take care of that after you've passed. It's really, really weird. But those are the things that are part of an estate. So why do we care about these things? What's the deal? Why do we care if we have an estate? Well, we ask a number of questions about estate planning. For example, at your passing, after your death, who's going to receive your assets? Again, assuming that we're not passing debts on to the next generation, and the answer is that we don't. They don't necessarily inherit the need to pay off any debts that you might have. So who's going to receive those assets? And then for me, in the estate planning decision-making tree is, how do I minimize the amount of legal fees or taxes or accounting fees or, transactional costs? I would like to make sure that my family receives my assets in the least expensive way possible. Now, if you became incapacitated, the questions there are, well, who's going to manage my assets if I'm not able to do that, right? So if I've been declared legally incapacitated and I'm not able to make good decisions for myself, who do I want doing that? And who's going to make medical decisions for me if I'm not able to do that? So the term estate planning, I'd like to get rid of that term. I'd like a better term. I came up with people stuff planning once upon a time because that makes a little bit more sense than the term estate planning. But in the legal world, estate planning takes into account planning for things that happen at your death and planning for things that happen if you become incapacitated. So in my book, what should your estate plan cover? We talked a little bit about this. I want to make decisions that make sure that things are taken care of while I'm still alive. If I become disabled, and then at my death, I want to make sure that I've outlined how things are going to happen. Who's going to do what? Who's making the decisions? Who's going to receive what? All of this is part of the estate planning process, including what if I'm incapacitated and I'm connected to, hospital equipment. I'm on a ventilator, or they're keeping my heart beating, and I'm unable to make those decisions anymore. If I'm cognitively unable to do that, who's going to make those decisions, and what decision do I want them to make? So this is all part of estate planning. Estate planning is actually pretty broad. We're not going to cover everything tonight, but we're going to talk about a few things. So let me talk to you about, I've been doing this for 35 years. Let me talk to you about some of the fairly common estate plans that I've seen over that time. The first one, which is the most common, is the do nothing plan, meaning I don't do anything. I don't care. I put my head in the sand. I don't want to make decisions. I don't want to think about dying. I don't want to think about being incapacitated. So that's the do nothing plan. By far the most common, just easily the most common. It is the least effective, but it is the most common. The second one, and people don't think of this in terms of estate planning, but it truly is, I just want to give assets away. Can't I just give this to the kids? I just want to give this away, and then I don't have to worry about it. I have stories. I don't think I'll get all the stories in tonight, but I have stories about how that one went off the rails. If I've got time, I'll mention that. A will is fairly common among people that do planning. The will is very common. The will is a set of instructions to the court about how things are to be divided up and how they're to be managed. And there's things like paying expenses and that. And that's the will. The will. The reason I say that's instructions for the court is because the will take us into the probate process. And I'll talk about this a little bit, but it takes us into the probate process. The revocable living trust is a set of instructions to my trustee. And the benefit of the trust is that it doesn't take us through the probate process. If we set it up appropriately, if we pay attention to it over the years, at my death, there's nothing in my name that needs to go through the probate. That's in the trust. So those are kind of the big four. Do nothing, very common. Give away assets, not as common, but a lot of people still do it. Do a will. Will's usually, not always by the way, but usually better than no planning. And a revocable trust can be a really nice planning tool. So the do nothing. The advantages of the do nothing, it's pretty obvious, right? I don't have to do anything. I don't have to think about it. I don't have to worry about it. I don't have to have my kids weigh in on it. I just don't have to do anything. And so, do you have an estate plan if you've done nothing? Well, the answer is, yeah, you actually have a will. Even if you didn't do it, even if you didn't sign it, the state legislature in 1974 adopted provisions of what we call the intestate rules. And the intestate just simply tells us what's going to happen if you die and you don't have a written will, all right? And so there's a whole set of instructions. Is that important? Oh, yes, it's terribly important. They came up with a default. I call this the default rules or the default will. And it's important because you've got to know what those rules are. Now, they were adopted in 1974. In 1974, I was in high school in a little town in eastern Montana. And in my little town, in my high school, I could count on maybe one hand, maybe two hands, the number of classmates or kids in school there that came from a blended family or came from, whose parents were divorced, and then even fewer whose parents were remarried. So is that important? Well, yes, because in the intestate provisions of the Idaho Code, all of your community property goes to your spouse, your present spouse, which is what most people tell me. When they come into the office and we're doing their planning, most of them say, well, I just want everything to go to my spouse. And then if my spouse has predeceased me, I want everything to go to my kids. Perfect so far. The fly in the ointment under those rules, though, is if I die and now all the community property goes to my spouse, to my wife, my new spouse, right? Not to my previous spouse, but to the spouse that I'm married to at my death, everything goes to her, and then she dies. Where do the assets go? Well, under the intestate provisions, those assets go to her kids, okay? They don't come back over to my kids. So they don't go over to the spouse and then down and then back over to my kids. They go over to the spouse and then down. So I have this over here on the far side of the slide. It says unintended, pretermitted family members. Okay, all that means is we left them out. They're omitted. So if I don't do planning, if I have a second marriage and we each have children from that previous marriage, and I don't do any other planning, then at my death, she gets the community assets. At her death, her kids get the community assets. So maybe I didn't want her kids to get the family farm. Maybe I didn't like her kids. But now her kids are going to get everything and my kids will get nothing. So that's the downside of the do nothing plan, is that we have to rely on what the state legislature adopted in 1974. Now, I know if you went back to that little high school in eastern Montana and you did a little research, you'd probably find that, half of the kids now come from a blended family. Not back in 1974. This provision, I think, is really outdated, but I don't know what you would write in now. So that's the problem with the do nothing. Now, if you're married to the same person you've been married to for years and years and years, and you have the kids together and all your kids are still here, it might not matter. And quite frankly, I've done a number of plans where we didn't do a will, because we knew that the will that mom was going to do was going to be the same thing as what the state legislature had put into their rules. So we didn't do a will. But if you have a blended family, that might not be the same thing. All right, well, let's just give away those assets. That's just much easier. Just give away the assets. Then we don't have to go through the probate process. We don't have to worry about state rules about intestate. So what are the issues? Well, I'm really gonna just talk about a couple, okay? The estate and gift tax issues, we'll talk about that in another presentation at some point. Let's shortly, maybe just cut to the chase. There are some issues with estate and gift tax issues when you give away. And that's some planning that you want to do very intentionally. You don't want to accidentally do that kind of planning by just giving things away. Many of you have heard that under the Medicaid rules, there's this 5-year look back. And if you've given away assets during that 5 years before you apply, then Medicaid can say, we're not going to pay. We're not going to pay, those long-term care costs for you. Actually, it's even more complicated than that. But the thrust of that whole thing is, if we needed the help from Medicaid, which can pay for long-term care, if we've given away those assets and we haven't thought through that, we may have made that impossible for us to receive the Medicaid. So Medicaid to me is a big issue because long-term care costs are so expensive. They are so high. If you were in skilled nursing in Idaho, the costs of monthly care in skilled nursing can range from $8,500 a month to over $15,000 a month. So skilled nursing is paid mostly by Medicaid. And if you want to do some planning, that's one of the places that you look, is at the Medicaid, and to get that assistance, that benefit when you get there. A second really big one for me is that when you make a gift, when you give that away, and it's truly a gift, you've lost control. You can't get that back. Unless you can go to your son or daughter and say, hey, I need that back now. I wasn't counting on needing this, and I do need it, and so there's a problem. Well, that could be okay unless you've given those assets to, say, a son whose business got hit during this whole COVID thing, and now they're filing for bankruptcy. Well, if it was truly a gift, that those are his assets and now are part of the bankruptcy estate. And so you've lost control, and you can't go into the bankruptcy and say, listen, I had my fingers crossed, so this doesn't count. You need to give me those assets back. That's not the way it works. Very close to that is you can't always count on the help from the family when you need it. My experience time after time has been something along the lines of, if you've got 3 or more kids, you've got one of the children that does really well with finances, doing well, good paying job, things are working for them. You've got one who is not that. That's a struggle financially. And so with that struggle, again, it could be a bankruptcy situation. They could be sued. They could be in a divorce situation. So you've got one who's doing pretty well that we can count on, one that we maybe shouldn't count on, and then often you've got somebody that's in between. So it really puts a lot of pressure on the family if you are going to give that away and then count on them being available to help you. That is not always available. Capital gains tax, that's again, that kind of kicks back to the estate and gift tax issues. If you give away assets, you've created capital gains taxes where you didn't need to do that. So again, if you're going to give away assets, that's something that you should be very intentional about. Visit with an attorney, visit with your CPA. There are tax issues associated with giving those assets away. So Danny, any questions?
None so far, Mark. You're doing great. Thank you.
Oh yeah, that's because I'm brilliant and I'm just doing a tremendous job in explaining everything.
Almost like you've done it before.
Well, that could be. I don't know if it's brilliant. Okay, so what's a will? A will, as I mentioned earlier, is the instructions for the probate court. I have had this question asked to me. I can't even count the number of times people have come to me and said, well, listen, I have a will. Since I have a will, we don't have to do probate. And the answer is no, that's not accurate. Even with a will, if we have assets that are held by you personally in your name at your death, typically to transfer title on those, you would need to sign those. You need to sign off on a deed, you need to sign off on a title, you need to sign off on the account. And so that's what transfers the ownership, is by signing that. When you're dead, it's really hard to get your signature. That doesn't mean it hasn't been tried, and I have a story about that. But if you're dead, we can't get your signature. So the courts came up with long ago this process where we go through the probate, and the first thing that happens is we get somebody appointed who then is authorized to sign on your behalf. So you're not aligned to sign off on a deed on the house, but the personal representative can, because they've been authorized to do that. And so even though we say in the will, I want the house to go to my daughter, until we've opened up the probate, we filed the paperwork in the court, we've gotten somebody appointed to be the personal representative, that house doesn't transfer over to my daughter. So even with the will, we'll do the probate. So will, those are instructions for the probate court, effective only on death, right? The will doesn't do anything before you're dead. It'll have instructions on how to manage the property, how to get the bills paid. And then in that will, you will have told us that I want my daughter or my son or my kids to get my house or the cabin or whatever it might be. That's listed in there. But we'll still go through the probate court in order to make that happen. Okay, so let's drop down a little bit. So what's a probate? Those of you that have been through the probate, you know what I'm talking about. If you've not been involved with the probate or have had experience with it, a probate is a legal proceeding. Some people have done this by themselves. Most people hire an attorney. The attorney files some documentation that opens up a court file, a legal proceeding. I'd say lawsuit, only we're not suing somebody. We're just opening up a case under the jurisdiction of the probate court. And then the court appoints somebody to be, we used to call them the administrator or the executor. Now, under the Uniform Probate Code, it's the personal representative. And that way we don't have to worry about he, she, they, them, it, all that other stuff. It's now just the personal representative, or the PR, is the term we use in the, in the legal field. The judge then follows the instructions in the will. Now, what if nobody likes the way the will works? Will the judge enforce it anyway? Well, if everybody agrees, you could actually change some of the provisions of the will. And we had a situation recently where we needed to do that. Gentleman did a do-it-yourself will. I don't think he realized that he cut his wife out of the will. he made no provision for his wife. Well, the kids didn't think that was right, and so we were able to make some changes. So then the property, once the personal representative is appointed, then the personal representative can transfer the property, has authority from the court. Those transfers are recognized by your county recorders and the title companies. One of the things, though, that a probate does, if we've opened up a probate, then we have a forum for a will contest. What if somebody isn't happy with the way that that will works? Well, they're probably out, but it's really easy for them to say, to file their own document and say, I object. And that will shut down a probate until the judge either tells the would-be heir, the person who's upset with the way the will is written, either the judge tells them they're out of luck, or the rest of the heirs agree to something. And my experience is it's generally that they agree that that person's getting more than what it says in the will. And sometimes it means they're getting something rather than nothing. But we can bring that will contest. That's really easy to open that up. And then the judge will tell us we're going to have a hearing on it. It delays the whole probate process. And when we delay it, becomes time consuming and expensive. Attorneys love it because we get paid more money, accountants get involved. And so now we're spending money. That doesn't happen all the time. It really doesn't, but it can. And it happens just enough that it's kind of a pain. So if that's a will in a probate, well then what's a trust? Just quickly, a trust is a set of instructions, basically, that I give property to my trustee with a set of instructions that says, here's how I want my property to be administered, to be managed. The trustee then follows those instructions. Now the trust, as opposed to the will, the trust is effective as soon as you sign it. And so then I can put some instructions in there that if I were disabled or incapacitated, the trustee then can follow those instructions and manage those assets. And what's wonderful about that is that that reduces or completely eliminates the need to do a conservatorship if I should become incapacitated. Because if the assets are in the trust, the trustee then has instructions, just follows the instructions. That is much easier than doing a conservatorship. So it tells us how to manage the property. It tells how to pay my bills. And then at my death, nothing's really changed as far as the trust. I still have a trustee. A trustee follows my instructions, and my instructions at that point are, I want property distributed to my kids. I want my house to go to my daughter, or however that might be. The trust is a wonderful tool in the situation of special needs children and how we want things to happen for their benefit. The trust allows us to manage property for their benefit and keep them from losing any of the governmental benefits that they might be receiving. So a trust can avoid probate. It can help me to avoid a conservatorship, and it can do a really nice job of protecting assets, especially in the situation of a special needs child. If I had a child that was in, say, a troubled marriage, and I didn't want the property that I'm leaving to that child to go to an ex-spouse, the trust can also do a really good job of protecting assets that way. And make sure that my grandkids get assets, because it can stay in trust for the benefit of my kids and then the benefit of my grandkids as well. In a blended family situation, a trust can work just extremely well in that I can say, listen, as far as my portion of the assets, I want that to stay in trust for the benefit of my spouse. And then upon her passing, then the assets go to my kids. So the trust is a very flexible tool. Yes, it's more involved than the other ones, but it's also very, very flexible, can allow us to do a lot of things. All right, well, we've talked about a number of different estate plans. Boy, that just sounds like a lot of work. Why don't we just do everything with the power of attorney, Mark? Well, first of all, as far as the assets at my death, a power of attorney is no good after I die. It's only valid while I'm alive. So as long as the principal's alive, then the power of attorney works. At my death, there's nothing, there's no, the power of attorney is no longer valid. There are a couple of other issues, though, that make the powers of attorney in and of themselves a little bit difficult and therefore not great tools for some of the things that we've talked about. For one, I've seen this, one of my first powers of attorney that I helped with was a young man who was headed over to Iraq. We did this power of attorney. He'd just gotten married, left everything to his cute little bride, and then he took off, and everything was good. A couple, 3 years later, he came back into the office, and in the meantime, he'd gotten divorced. And when he was divorced, his cute little bride used the power of attorney to empty out the account and sell the house. Left him in a real tough situation to get some things taken care of. So something to keep in mind with the power of attorney is not really a good method for accounting and responsibility about how that power of attorney is used. Now, don't sit there and go, okay, well, I'll never have a power of attorney. No, that's not the right answer. It's just that there are some issues with that. Join us next month, and we'll talk more in depth about that. The other thing about a power of attorney is make sure that it's executed properly. We've observed the formalities. I have run into issues with some of the banks and other financial institutions. If that power of attorney is even 6 months old. If it's over 5 years, I've really struggled to get a power of attorney accepted by a bank or financial institution that hasn't ever seen it before. They're just like, well, you know, isn't there a power of attorney that was done, you know, in the meantime? And so if it's 10 or 15 years old, that power of attorney can just be a nightmare. And we find out, of course, after the principal is incapacitated and we can't sign another power of attorney. That's a real issue. So join us July 28th. We're going to do this little thing again, and I'm gonna focus in on those powers of attorney. So a lot of people then say, well, so what's this thing about a living will? I'm just throwing this up here just to keep you in mind that a living will, in Idaho we call a living will. It's not a great name, I don't think. Other states call it an advanced healthcare directive or an advanced directive, and the living will often combined with a healthcare power of attorney. And that's what we'll talk about on the 28th of July as well, the healthcare power of attorney. The living will allows us to communicate some issues or some things that we would like to have happen now. So we put that together and we put that into a living will and our power of attorney for healthcare. And then if we became incapacitated, people would know what it is that we want to have happen. So if I have no brain activity, or if I'm terminal, likely to die, unlikely to have restored capacity, and I'm being kept alive by, you know, some of the machinery, this allows me to say, you know, I don't think I want that. If I get to that point, I think I just want you to disconnect me and let me go. Well, the other options are we could keep you alive as long as possible, or we could disconnect everything except providing, you know, nutrition and hydration. So that's just a way that allows me to make these decisions and put those on paper so that down the road, if I become incapacitated or I'm not able to express my wishes, then I've got that on paper. And then my durable power of attorney for healthcare can just make sure that my wishes are followed. So I put that in because that's a question that comes up a lot. We'll talk about that more on the 28th. Okay, so where
Mark,
to start?
We've got a
Yes,
question.
Absolutely.
They're looking for clarification that a trust to be considered in effect, they'd have to be signed and notarized. Is that correct?
Well, the answer to that is no, it doesn't need technically to be notarized. I would recommend that it is, okay? And there are reasons for that, but doesn't have to be notarized. A will doesn't need to be notarized, but it needs to be witnessed by 2 people. So you have to have 2 witnesses. A trust doesn't need the 2 witnesses. Really doesn't need to be notarized, but I would not do it that way. I would make sure that it is. Is there a follow-up question to that? Did that create more questions?
None in the chat so far.
Okay, very good. All right, so where to start? I'm gonna kick this ahead one. I wrote a book, and I can do this. I really can, I promise. I wrote a book. It's called Get Real, Planning for Life, Death, and Disability, and really kind of walked through 5 steps to get organized and to take care of yourself and your loved ones, you know, your family. So in that, I just lay out 5 steps because it's hard for people to do that. So the first thing was to get real. And what do I mean by get real? Well, it's really easy for us to put our head in the sand and just we don't want to make a decision, or it's difficult to make a decision. And for a lot of people, it's I don't even know where to start. So in the book, I walk through that a little bit. 2, get motivated. And so how do you get motivated for this? Well, for me, it's all about the people I love. That's why you do this. If you're thinking, if your financial advisor or somebody else has been telling you for years, well, you need to get a will done or you need to get estate planning done, don't do it for them. Don't do it for them. Maybe don't even do it for you. Do it for your loved ones. You know, when we get married, we make some commitments to loved ones, to a spouse, and you know what? We committed to take care of them. And one way that we can do that is to get our planning put together. We can organize our stuff. We can help to make decisions now. So if it's not yourself, then maybe your sweetheart. If not your sweetheart, then the kids. I have 5 grandkids. The youngest is 2 years old. You know, and sometimes it's easier to just forget about the kids. And if it's the grandkids, get motivated for the grandkids. Step 3 for me in the book is to get it together. There's a bunch of stuff that it would be very helpful to pull together so that you can get, you know, make some decisions and get your plan doing what it is that you want it to do. Step 4 is get some help. Yeah, you probably need an attorney. That's a good place to get started. But if you've got a financial advisor, get help from a financial advisor. If you've got a financial planner, you know, get together with your financial planner. You got an insurance guy or gal, get together with them. Get some help. And then step 5 is just get her done. I think it's Larry the Cable Guy that talks about get her done. Yeah, get her done. So if you are interested, you know, you can go to my website, idahoestateplanning.com. And if you log on, we will send you a free copy of the book. And it's, you know, I don't have photos in it or cartoons, but it's not a very long book. So it's an easy read. And just the effort was to help you get going and get thinking about some things, talk about some of the options, and, you know, kind of ease you into that whole process of getting started and getting going. So that was yeah, it's within the window. I said it might be, you know, 45 minutes. So there you go. That was the kind of a, I know you're all going, that wasn't that brief, Mark, but that was kind of a brief overall view of estate planning. If you have more questions, you can get on our website. A lot of information on there. I have for the last 5 years done a radio show every Saturday on KBOI. We've captured all of those. Those are all recorded and on the website. A lot of good information. There's some videos. There's all of our blogs are on there. So there's a lot of information. If you like to just, you know, to study it out, get on there, get some information. If you have questions, it'll tell you how to get hold of me. If you have an attorney that you've worked with before, great. I'm just recommending you get going and get it done. Any other questions?
Thank you, Mark. I'm going to give a few more seconds for people to speak up if they want to they want to chat us, or I believe they can unmute themselves. If you're having trouble doing that, please let me know. Yes, thank you, Michelle, for posting that on the side. We will be able to, if you know someone who would benefit from this information that wasn't able to make it to tonight's Zoom program, we will have the links to it available on our website soon. All right. Well, if no one else has any questions for Mark, I want to just say thank you again so much for working with us and for joining us this evening and giving us an overview of all this content. It was very helpful, and we look forward to seeing you again next month.
Let's do it again on the 28th.
All right. That sounds good. Thanks, everybody.